So for Module 2, Maria and I are going to be discussing the history of U.S. copyright law and the violation thereof, specifically in the form of media piracy. So the OED defines a copyright as the exclusive legal right given to an originator or an assignee to print, publish, perform, film, or record literary, artistic, or musical material, and to authorize others to do the same. So to look a little bit at the history of U.S. copyright law specifically, questions surrounding copyright law inspired by the British Statute of Anne began around the mid-18th century, although an official act was not debated until 1783 in the new United States, when the U.S. Continental Congress passed a resolution that empowered states to secure to the authors or publishers of any new book not hitherto printed the copyright for up to 14 years after publication, and another 14 years if the author was still alive at the end of the first term. In the years following, all but one state instituted individual copyright laws. An official federal copyright clause was included in the U.S. Constitution in 1787 in Article 1, Section 8, Clause 8, which states, "The Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries." The power was enacted in the Copyright Act of 1790, which ensured the right to publish and sell maps, charts, and books for two 14-year terms, so long as the author met particular requirements, such as providing a copyright notice. This act failed to protect other forms of writing and copying foreign works. The first official revision to these laws was not written until 1831. The Copyright Act of 1831 changed the copyright limit from 14 to 28 years and provided an opportunity to renew rights. 3 years later, in the Supreme Court case Wheaton v. Peters, the court ruled that authors did not have copyrights over reproductions of their work after the first publication. For the most part, U.S. copyright law remained the same until 1976. Both federal and state governments established copyrights. Federal government protected works that were registered, whereas state copyrights also protected unregistered works. The 1976 Copyright Act, however, did away with this dichotomy, ruling that all legal or equitable rights that are equivalent to any of the exclusive rights within the general scope of copyright, as specified by Section 106, in works of authorship that are fixed in a tangible medium of expression and come within subject matter of copyright as specified by Sections 102 and 103, whether created before or after the date and whether published or unpublished, are governed exclusively by this title. Therefore, no person is entitled to any such right or equivalent right in any such work under the common law or statutes of any state. So essentially, this act extended federal copyright protections to unpublished works, which was previously exclusively granted by individual states, and it also ensured copyright protection for up to 75 years or the rest of the author's life plus 50 years. A number of revisions or addendums to the copyright law were introduced in the decades at the end of the 20th century. This included the Berne Convention Implementation Act of 1988, establishing the United States as a member of the Berne Convention for the Protection of Literary and Artistic Works. This ensured that copyright formalities were no longer required in order to protect works. However, while the Berne Convention included a grandfather clause that countries must grant copyrights to foreign works that were not previously copyrighted, the U.S. refused to accept these terms. 4 years later, the Copyright Renewal Act of 1992 and the Copyright Amendments Act of 1992 renewed the Copyright Act of 1976, but eliminated the requirement for registration in order to renew copyright protection. So while registering and applying for renewal grants creators particular rights, it's not necessary in order to renew general copyrights. The Copyright Amendments Act of 1992 also included the National Film Preservation Act, which authorized the National Film Preservation Board for 4 years. It also required the Librarian of Congress to report film preservation and restoration activities to Congress and established a national preservation program for motion pictures. In 1994, Congress adopted the Uruguay Round Agreement Act, which established copyrights for the aforementioned foreign works that the U.S. refused to copyright with the adoption of the Berne Convention. And then finally, in 1998, Congress extended the terms of U.S. copyright from 50 years after the author's death to 120 years after creation or 95 years after publication in the Copyright Term Extension Act of 1998. So this brings us to the relatively modern day, the 21st century, looking at digital copyright and digital media. So the end of the 20th century also marked the beginning of issues surrounding digital copyright violation and policy. Many of us remember the anti-piracy PSAs from the early 2000s that compared car theft to illegally downloading media, but how did this all start, and is that really a fair comparison? The Digital Millennium Copyright Act of 1998 marked the foundation of continuous evaluation of copyright law due to the constant development of new media and technology. The U.S. adopted two of the treaties from the World Intellectual Property Organization. These two treaties included the Anti-Circumvention of Access Controls and Technical Protection Measures, as well as the Safe Harbor provision, which protects service providers from liability for infringement of third parties. The Act amended Title 17, the original copyright clause, in order to criminalize copyright piracy and ban devices that allowed for this piracy. The Safe Harbors provision protected Internet service providers from being held liable for copyright violation by third-party users. It includes the Notice and Takedown Clause that grants access to copyright holders to disable content that infringes on copyrights. The DMCA received wide criticism surrounding these two clauses. Many critics allege that the Notice and Takedown Clause is vulnerable to abuse by copyright holders in order to block content from competitors, and critics also accuse the DMCA of favoring large copyright holders over small ones, limiting the rights of small copyright holders. Many also allege the clause allows for overbearing censorship. While the DMCA attempted to limit piracy and regulate online access and distribution of pirated materials, the Act was ultimately ineffective in circumventing digital piracy. Prior to the start of the millennium, experts estimate that $265 billion and 4% of total box office profits were lost due to digital piracy. By 2005, experts estimated that digital piracy led to a loss of over $50 billion per year from the film, software, and music industries. Napster, a music torrent site, launched in 1999 and soon became a hub for digital media piracy. Napster enabled P2P, or peer-to-peer file sharing, used later in sites like BitTorrent. Napster was later shut down in 2001 per a federal court ruling. Napster marked the beginning of media piracy, although its end did not close the book on torrenting and pirating. LimeWire, a similar torrenting site, used similar file sharing programs, albeit in a decentralized method using BitTorrent clients. This method set up an example for future torrenting sites, many of which are still in use today. Peer-to-peer sharing sites Grokster and Streamcast came under fire in 2005 when they were sued by 28 of the country's largest media companies. The U.S. Supreme Court ruled that peer-to-peer file sharing websites were liable for violating copyright infringement by using this file sharing software. This differed from the precedent set by the Sony Betamax case, which ruled that VCR and VHS manufacturers are not liable for copyright infringement. The court ruled, stating that one who distributes a device with the object of promoting its use to infringe copyright, as shown by clear expression or other affirmative steps taken to foster infringement, is liable for the resulting acts of infringement by third parties. As a result, Grokster removed its peer-to-peer file sharing software from its website and was ordered to pay $50 million to the consortium of plaintiffs. Following the ruling of MGM Studios versus Grokster, CEO of peer-to-peer sharing site LimeWire, Mark Gorton, said that the site would remove its file sharing capabilities. However, in 2007, Arista Records, along with 13 other major record labels, sued the site for copyright infringement due to its torrenting software. An expert witness found that 93% of the content distributed by LimeWire was copyrighted and was distributed without authorization. As a result, LimeWire countersued, citing antitrust allegations. The suit was later dismissed by the court. 3 years later, the court ruled on the original suit that LimeWire was liable for copyright and common copyright infringement, as well as anti-competitive practices. The lawsuit resulted in a permanent injunction for LimeWire, prohibiting the site from copying, reproducing, downloading, or distributing a sound recording, or allowing users to do the same. The original site shut down not long after the ruling. However, new versions of the site continue to pop up to this day. All of this led the media industry to the realization that copyright laws do not prevent piracy. It also led content creators and distributors to look to advancing technology in order to create physical barriers to prevent piracy. A DRM, or digital rights management, is software that empowers distributors to control and manage their content. Content Scrambling System, or CSS, is one example of a DRM, and it's a way for DVD manufacturers to protect the content on their discs. The development and increased popularity of streaming software and subscription services were also predicted to help curb the extent of media piracy. However, as we will see in our next section, this has not been entirely effective.
The first issue I want to look at is the international issues with media policy. There is no such thing as international copyright that will automatically protect a work throughout the world. Protection against unauthorized use in a particular country depends on the national laws of that country. Original works of expression that are eligible for copyright protection are protected under national copyright laws. Protection against unauthorized use in a particular country depends on the national laws of that country, as I said earlier. So in other words, copyright protection depends on national laws where protection is sought. International copyright conventions and treaties have been developed to establish obligations for treaty member countries to adhere to and implement in their national laws, thus providing more certainty and understanding about the levels of copyright protection in particular countries. Many countries offer protection to foreign works under certain conditions that have been greatly simplified by international copyright treaties and conventions. The United States is a member of many treaties and conventions affecting copyright. These treaties help the copyright laws to stay consistent internationally. It's also important to mention the World Intellectual Property Organization, WIPO, and they administer some of these conventions that I talked about previously. Next, I want to talk about problems with piracy today and recent piracy issues. For example, one recent piracy issue comes with Google versus Oracle. Google and Oracle are two of the biggest tech companies against each other, battling over the country's top smartphone platform. With the potential for tens of billions of dollars in eventual damages, the companies have already been fighting for nearly a decade. Oracle is accusing Google of stealing copyright pieces of Java software language when it built the Android smartphone platform. Oracle says Google copied important elements of so-called application programming interfaces, and Oracle helped programmers more easily write in Java and use them in Android. Google fought back by arguing that the pieces it used from the interfaces were too functional to be protected by copyrights, but the Federal Circuit rejected that argument in 2014. This ruling will be the first time the court has tackled copyright law's fair use doctrine in more than 2 decades. This will be the first time the justices have ever ruled on software copyrights. Another one to mention is the Spotify. When Spotify was hit with a 1.6 billion copyright infringement lawsuit in 2016. Spotify has been sued because a music publisher claimed the streaming service has been using songs they administer without license. Wixon Music Publishing stated a paperwork in December of 2017 that stated Spotify was improperly using more than 10,000 of their songs, including Tom Petty's Free Falling and Mariah Carey's All I Want for Christmas Is You. Wixon Publishing president said in a statement that he's not looking for ridiculous punitive payment, but just asking to be treated fairly. Music fans should be able to enjoy Spotify knowing their favorite artists are being treated fairly. I agree with this statement because I use Spotify and I wouldn't want to be a part of using an app that is not complying with copyright laws, and I do think these music artists should be treated fairly. Next, I want to look at preventing copyright issues. Twitch, which is the world's leading live streaming platform for gamers, where you can watch and chat with millions of other fans from around the world, launched a creator platform for artists to avoid streaming copyright issues. Streaming artists on Twitch were growing tired of the takedown of their streams and clips due to copyright music detections in their videos. Since Twitch doesn't have music licensing agreements with Universal Music Group, Warner Music Group, or Sony Music Entertainment, any music under those labels gets flagged. In turn, streamers find themselves in difficult positions when creating content on the platform. As a result, Twitch has announced they are introducing their own streaming service called Soundtrack. It'll feature a large collection of rights-cleared music that creators can utilize. The new platform, Soundtrack, offers creators a library of music from independent artists that are available to be played in stream sans copyright issues. Much like other streaming services, Soundtrack will feature their own specially curated playlists for creators to explore a specific genre. Next, I want to talk about YouTube and copyright law. Grammy-winning composer and musician Maria Schneider and Pirate Monitor Ltd. filed a class action lawsuit against YouTube for copyright infringement, claiming YouTube does not afford them the same opportunity to remove infringing work as larger content creators, and that infringing work that is removed from the platform is often re-uploaded and posted by users without repercussions. The plaintiffs, which are ordinary creators of copyrighted works, claim YouTube is infringing on the rights of copyright holders. They added that YouTube has facilitated and induced this hotbed of copyright infringement through its development and implementation of copyright enforcement system that protects only the most powerful copyright users, such as major studios and record labels. But YouTube is trying to work on its copyright issues. Creators should only upload videos that have made or that they've authorized to use. This means they should not upload videos that didn't make or use content in their videos that someone else owns the copyright to, such as music tracks, snippets of copyrighted programs, or videos made by other users without necessary authorizations. Fair use is a U.S. law that allows the reuse of copyright-protected material under certain circumstances without getting permission from the copyright owner. However, fair use is determined on a case-by-case basis, and different countries have different rules about when it's okay to use material without the copyright owner's permission. In the U.S., works of commentary, criticism, research, teaching, or news reporting might be considered fair use, but it depends on the situation. YouTube created an audio library to help creators reuse content safely by providing free high-quality music and sound effects. Next, I want to look at Instagram and copyright law. What can and can't you do with other people's Instagram photos by Madeline Buxton was an incredible article. She covers how there's a good chance you've infringed on someone else's copyright on Instagram without even realizing it. You can't take someone else's photos without their permission and profit from them. It does raise an important issue. The ease of sharing on social media, combined with the lack of knowledge around what counts as copyright infringement, means people's work is also used without their permission. There's a good chance you've infringed on someone else's copyright on Instagram without even realizing it. To share someone else's Instagram photo, you need their permission. At the end of the day, you own the rights to the photos you post.